I'm Danielle Citron. I'm the co-director of the Law Tech Center, along with the glorious Elizabeth Rowe. Don't laugh at me. The country's trade secret expert, extraordinary lawyer and scholar. So I'm really lucky I have Elizabeth at my side. We welcome you to this amazing event. So what I'm going to do is, first I'm going to introduce our speaker, our author, my co-moderator, and then Dr. Franks is going to come, our author is going to come talk about the book for about a half an hour. And then Elisa and I are going to sit with Marianne and ask a few questions, but really we want you all engaged. So hoping, and of course everyone gets their copy of the book, which is so exciting, right? I have my very marked up every ear dog page from, I got an advanced early copy, so mine, I love the idea that I have every page just got something going on there. So that's our plan for today. So let me introduce our author, Dr. Marianne Franks. She is the Eugene, she's got a very fancy title, so I'm going to say the whole thing. Eugene L. and Barbara A. Bernard Professor in Intellectual Property, Technology, and Civil Rights Law at GW Law School. And before that, she spent many, many years at, though she's very, very young, but years at University of Miami School of Law. Dr. Franks, she's a Renaissance person. She is a teacher, scholar, and advocate extraordinaire. She is the international go-to expert on so many fields. I'll just name a few, but criminal law, family law, free speech, the First Amendment, the Second Amendment, criminal procedure, law and tech. There's so many, there's not a thing actually you can't teach. Marianne, she is the president and legislative director of the Cyber Civil Rights Initiative, which had a birthday last year. It's 10 years old. And so Dr. Franks wrote the very first proposed sort of model legislation on non-consensual intimate imagery in 2013. And at the time, there were 2 states that had invasions of sexual privacy along the lines of the disclosure or publication of intimate imagery. There were only 2. Right. We now have, because Dr. Franks has worked tirelessly testifying, and the Scrivener, they don't always listen to Dr. Franks, but we now have 49 states. So think of this, in a decade, going from 2 laws to 49 states. DC, Puerto Rico, and Guam all have laws that penalize, criminalize, and also some civil penalties with regarding to the posting of non-consensual intimate imagery. And that those laws, and speaking of fearless speech, those laws have been upheld in the state's highest courts, where they've been challenged, and each time they've gone through the crucible, for the most part, of strict scrutiny and come out the other side upheld. In addition to 50 highly cited law review articles, right, and being among the top law and tech scholars and just generally influential scholars, she's written, her first book was award-winning. It's called The Cult of the Constitution, Our Deadly Devotion to Guns and Free Speech. And now we're so lucky to have Dr. Franks in the beginning of a book tour for fearless speech, breaking free of the First Amendment, which of course we're here to discuss and celebrate. She was at Politics and Prose last weekend with Mark Joseph Stern as her commentator. If you're in New York on November 25th, Dr. Franks will be with Ali Velshi at the Strand in New York City. My kids are so going with flowers. So all of our New York friends and my sister and my niece will be there in New York City. So if you're there in New York at the time. So that's Dr. Franks. Thank you so much for coming. It's been really a life's honor for me to work with Dr. Franks at the Cyber Civil Rights Initiative. I always say I'm like her sidekick. I'm her vice president and the secretary. So we have so much fun together. And joining Dr. Franks is Elisa D'Amico. Don't give me that, right? Elisa has been, so at the time that we started, even before we started the Cyber Civil Rights Initiative, Dr. Franks co-founded with Holly Jacobs, we were starting to think about, at the state level, of course, after Dr. Franks wrote the very first model statute, in Florida, our founder of the Cyber Civil Rights Initiative, Holly Jacobs, was facing non-consensual intimate imagery all over the internet. And Dr. Franks and Holly and Elisa D'Amico got together and all testified and worked with lawmakers in Florida to get to criminalize non-consensual intimate imagery. And then Elisa is at K&L Gates. And she says to her partner, David Bateman, there are so many people suffering. They need pro bono counsel. Let's start the Cyber Civil Rights Legal Project, a pro bono effort at K&L Gates, still the one and only firm to do this. And please, all my cute law students, please listen, like, let's emulate them, right? But to start a practice in which they welcomed victims of non-consensual intimate imagery to come to the firm. And they dedicated between 50 and 75 lawyers to the project. The New York Times sort of covered this. So in September 2015, they started the Cyber Civil Rights Legal Project. And so as soon as the New York Times had covered what they were doing, they had 100 clients immediately and have kind of never stopped. And Elisa has been at the helm of helping us understand how we represent individuals who are experiencing intimate privacy violations, and now has her own law firm. So I am my co-moderator. Thank you. We are in this together. So Dr. Franks, it's all yours. Thank you so much for being here. It means the world to me. And I'm going to let you take over.
So I know that all of you don't need to be told this about Danielle because you have the pleasure, the privilege of knowing her as a professor and a colleague, but you can tell from that introduction that you are, there's nothing I can think of being more important, especially in this sort of day and age, than to have friendships like the one that I have with Danielle, like the one that I have with Elisa D'Amico. And I'm so glad that you gave this history of how we know each other and how long we've been working together, because this book is about fearless speech, and I'm going to talk about what that concept means and why it's so important and why people who are truly courageous and are able to speak out even though there are consequences for this, why that's so important and why that's so meaningful. And I couldn't think of two more fearless speakers that I have had the privilege to know that are sitting here in this audience and are willing to engage with me about this work. So I am really indebted and really just honored to have this ability to have this conversation and to continue this kind of solidarity. So thank you for that introduction, and thank you both for being here. I thought, where I would start today is to tell you a little bit about why I wrote this book. And, obviously it came out just before the election, so I had hoped that we would have different conversations after the election. I was hoping that maybe these were not going to be the conversations we'd have, and that maybe, as I was saying earlier this morning, I did an interview with Dahlia Lithwick, and I was saying to her that I really wish that sometimes my work would become less relevant. That would be nice, but the reason why I wrote this, Danielle mentioned that several years ago, 2019, I published my first book, and that book was called The Cult of the Constitution. For those of you who may know a little bit about it or know a little bit about my background, it was meant to be a book about the similarities that I saw between religious fundamentalism. I grew up in a Southern Baptist household in Arkansas, and the parallels between that kind of religious fundamentalism and constitutional fundamentalism. And it was about how people will take a text, whether that's the Bible or whether that's the Constitution, and they will read it in a way that really is very indulgent towards their own self-interest or does validate their worldview, and then insist to others that that is the only way to read that text. And it won't be a conversation where people will say we can have disagreements. It'll be a conversation where people say you are evil, you are unpatriotic, you are out of the fold. And how alarming I thought that was, because the power of the Constitution in the United States is such that we learn about it, when we're very young. We're taught to revere it. And when you develop the sort of lack of critical space between you and that text, and you become convinced of your righteousness, it's really alarming. And it's really ironic when it comes to things like the First Amendment, because we're told that the First Amendment is supposed to be above all of that, right? The First Amendment is supposed to keep us in check. It's supposed to help us be critical. It's supposed to help us be tolerant of opposing viewpoints. It's supposed to keep us in a space where we can say what we want. We can be wrong. We can be provocative. But what happens when we have this fundamentalist attachment to the First Amendment or the Second Amendment is, instead, what happens is we become convinced that our way of doing things is the only way. and that everybody else is anti-American, everybody else is trying to destroy everything that's valuable about our country. So the book was about trying to talk about that in a way to sort of set up this framework about how tragic that was, that we are losing the aspirational potential of the First and Second Amendments of the Constitution generally when we have that kind of attitude. And what this book was intended to be was, it was intended to be just the focus on the First Amendment and free speech, but not just focus on the law. So I say early on in the book that this is a book that is about speech first, and it's about the law second, because speech is so much more important and comprehensive and interesting and provocative and strange than the law ever could be. It may be a slightly odd thing for a law professor to be saying, but I'm constantly in the position of saying, to my students, let's think about the limitations of the law. Where is it where the law doesn't help us very much? Where is it where the law is actually getting in the way of our tolerance, or getting in the way of our respect for each other, or getting in the way of being realistic about the world around us? What are the places where the law just can't help very much, even when we hope that it would? What are all the ways that the law fails? And that's really what I'm trying to talk about first and foremost in this book, is to say there are failures in the law. The failures of the law are not failures of people, because my book really is a celebration of people. It's a celebration of speakers. It's a celebration of that idea that you can use the power of language, the power of speech, to do good in the world. And you can do that, and some people have done that at great cost of themselves. But that has been, I would say, in the United States, hijacked as a First Amendment story. It's been hijacked as a story about the law and lawyers and a celebration of how, whether it's the ACLU or whether it's some famous Supreme Court case that says that's basically your canon, right? You need to think about the Nazis in Skokie. You need to think about Charlottesville, right? All of these, supposedly brave and principled stances for unpopular speech. That's what we get told we have to think of as the limits of our First Amendment jurisprudence. And I find that very limiting. So the subtitle really does mean what it says, that breaking free does not mean discarding. It doesn't mean saying the First Amendment is useless or that it's not something that we should honor. It's to say that it's incredibly limited in multiple ways that we can talk about in some detail and discussion, certainly, but I can also give you a preview of what I'm trying to say here. The most important thing, I think, about the First Amendment is its power, or its at least aspirational power, to say the government should not be able to punish you simply because it doesn't like what you're saying. That is the principle that I think is the most defensible, the most intelligible, the most noble in some ways, right? And to the extent that we can honor that, that is extremely important. In my book, I say the second thing about the First Amendment that I think is incredibly compelling is the fact that we have these famous cases that say you should not be forced to say things against your will, and you should not be forced to associate with ideas that you find disagreeable. Now, it's interesting how those two things work together, right? Because on the one hand, we want to make sure that the government is not able to discriminate against us or to punish us because it doesn't like what we're saying. But as private individuals, we absolutely have every right to say, I don't want to listen to you, or I don't want to promote your speech, and I don't want to endorse your speech. The problem that I've seen taking over, certainly American discourse about free speech in the last decade or so, is a confusion about those things. The entire emphasis on the whole cancel culture idea, the idea that we need more tolerance in places, mixes up those two things. We need our government to be tolerant in the sense that we need the government not to punish us simply because we're disagreeing with the government. When it comes to everything else, we need a different model. A university is not the government, even if it's a public university. A social media platform is not the government, even if it's a very powerful social media platform. We need to have different and better, I would say, measures of what counts as a good community, a good space, a free speech promoting space, and we don't want to borrow from what is very narrow in our First Amendment law, which is about the government's ability to punish you. What I worry about the most is that because we are not able to see those two things separately, we get exactly what we've gotten today. And let me say how I describe how we've gotten here today. I said this at an event last week where I guess I would presume is probably a more hostile audience than maybe this one would be. I was at the Buckley Institute at Yale. And what I said 3 days after the election was, if we're going to talk about free speech, And we're only going to keep churning out the same sort of cliches about how, oh, really the problem with free speech today is cancel culture. Really the problem with free speech today is that there are too many DEI initiatives. Really the problem with free speech today is that students, are heckling judges. My point of view was to say 3 days after this election, where the person who won the election has described himself as a dictator, whose former chief of staff says that man is a fascist, whose own vice president said he's America's Hitler. That's the person who got voted into office. And that is someone who has always made clear from his first campaign, from his first term, continuing to now, to say, I'm going to, or I want to be able to jail my enemies. I want to be able to silence people who criticize my Supreme Court justices. I want to be able to subject protesters at my rallies to physical violence. I want the press to be vilified, and I want them to be attacked. I want people to lose their citizenship if they burn the American flag. This is a person who's made really clear what his views on speech are. Then they are antithetical to anything that we could claim as a First Amendment tradition. And that is who got voted into office. That's a failure of the First Amendment. That's a failure of free speech. Whatever we're doing here with our conceptions of free speech means that we did not protect ourselves from fascism. That's a serious failure. And all the values that we think of when we think about why it is we need the government to not punish people for their viewpoints, the values are supposed to be truth, autonomy, democracy. What happened? What happened is that we got an information environment that was absolutely flooded with lies. Flooded. We got an environment where the truth was impossible to find, even if you were invested in trying to find the truth. What did we get in terms of autonomy? Well, we certainly got some speakers who felt incredibly emboldened and empowered to say whatever they wanted, including threaten, including harass, including calling for the extermination or the rounding up of their enemies. All those people got their autonomy to be respected, but what happened to everyone else's autonomy when it came to expressing themselves? How many women, how many people of color couldn't say what they wanted to say because of the threats of violence, because of this regime everywhere that says you should not be able to speak your mind or you will be subjected to violence and to threats? And then what happened to democracy? What happens to democracy when you can't inform the public of the truth? Now, of course, a million concessions as law professors and just as people generally, what is the truth? Who gets to decide? That's fair. We can have genuine conversations about real debates. We can certainly have long conversations about the correct opinions for certain issues, but there are also some things that are just facts. And the idea that we're living in a thoroughly, completely postmodern environment where no facts exist and everything is just a matter of constructed reality is not a democratic environment. Hannah Arendt said this many years ago. She says, when you take away the people's ability to distinguish between truth and falsity, you've taken away the ability for that people to have any kind of autonomy, to have any kind of democracy. She says, with those people, you can do what you will. It will be nothing but power. So my view of this, even before the election, was whatever we are calling and congratulating ourselves about when it comes to our freedom of speech theories, our First Amendment law, whatever the case may be, it has been failing us for decades now, if it ever worked. And what we can see now, certainly as clearly as possible, is how completely that failure is going to affect all of us, because it's a complete shutdown at this point. In my book, I talk a little bit about Elon Musk, more than I'd like. And one of the things I say there is that when he bought Twitter, he says, I'm going to turn this into the public square. I'm going to truly protect free speech. That was his whole dynamic, was to say, I'm really going to take this space and I'm going to genuinely let just all free speech bloom. Now, one of the first problems with this is all of the First Amendment scholars and even people who just have a passing familiarity with the First Amendment know, first of all, there's a real conflation there between the First Amendment and free speech, the government and a social media platform. The idea that moderation or taking down neo-Nazi content is censorship is not, that is a basic misunderstanding of how these things work. So he says, I'm going to believe in free speech. I'm going to honor these principles that are given to us or communicated to us through the First Amendment. And what does he do? Well, he reinstates a bunch of Nazis. That's the first thing he does. And the second thing he does is he bans or suspends or severely limits people who criticize him. And so at that point, some people who were up to this point thinking, oh, he's going to be good in the civil libertarian sense, this is going to be great because social media platforms have too much power. Some people were saying, this seems not great. In some ways, this is not what you're not supposed to be eliminating your enemies and just, boosting your allies. That's not what we meant by free speech. And my view on this, as I say in the book, is in some ways, he's the perfect example of exactly how the First Amendment tends to work in practice. We say that it's about free marketplace of ideas. We say it's about allowing everyone to speak. But what often happens, of course, there are exceptions. There are some really good First Amendment cases, but what happens overwhelmingly in our society is the people with the most power, the people with the most privileges, they get to speak and speak and speak, and everyone else gets drowned out or they get pushed out. So what you're watching when you see Elon Musk's takeover of Twitter, when he says, I'm going to fire all the content moderators, I'm going to disband the Twitter Trust and Safety Council, which our organization was part of. We found out an hour before we were supposed to meet with him that he was like, actually, I've just disbanded it. And I will be clear, the Trust and Safety Council was a fully voluntary group. It was NGOs, experts who were advising, as we did with many companies, advising them as to some of their complex issues when it relates to abuse and privacy. We were not employees. We had no control over what kind of decisions Twitter made. But one of the things that Musk did, in addition to just disbanding the council, was he went on Twitter and he talked about and he falsely claimed that the Trust and Safety Council was responsible for child porn on the platform. 2 of our members had to go into hiding. This is not just about someone who's claiming to do free speech and then not doing it particularly well. This is someone who's wielding power in such a malicious way and doing it in the name of free speech. And the marketplace that we keep talking about of ideas, I've tried to say in more recent years that the problem with the marketplace of ideas metaphor is not that it's not an accurate one, it's that it's too accurate. And if you actually think about what a marketplace is and how it operates, you wouldn't be praising the idea of the marketplace of ideas. That we would not really want to collapse our civil libertarianism into economic libertarianism. Because what does it mean? It looks exactly like X under Musk. Get rid of your enemies, amplify the people that agree with you, and completely flood the entire information environment with false things that hurt people. And I don't mean hurt people in that, people will criticize you or they're not going to like you. Hurt them in the sense that you will put them in danger of their lives. That's what a marketplace does when you say, I'm going to just take the guardrails off. It doesn't actually mean that. It doesn't mean we're going to have free speech for everyone. It means I'm going to pick winners and losers, and that's what's going to happen economically and otherwise because there are no more guardrails. And the fact that we can't see that that is an anti-free speech position is very troubling. And that was bad enough when it was a private platform. That is to say, it's a corporate platform as opposed to a governmental entity. But now what? Now Elon Musk is the government. So here we are. Elon Musk is now going to be a person with not only all the riches in the world, he's the richest man in the world. Not only is he controlling basically the major information platform that was decisive in the results of this election, he's also now going to have actual governmental power. This is a man who in the last few weeks has said, not only because he's been suing all the people that criticize him, like he can't stop suing, right? So he's suing nonprofits, he's suing individuals. He's now saying, and said this before the election results were in, but started to say more than that. He said, I think my enemies should go to jail. These nonprofits who are criticizing me, these advertisers who are boycotting Twitter because of the neo-Nazi content should be in jail. That is the person that Donald Trump says, that's who I think should be really embedded in the government. So if we wanted a marketplace of ideas, we got it. That's what this looks like. And that means that we have failed in the very minimal, one job that the First Amendment had to do, which is you don't want the government to have that kind of power. And now it does. So what I'm trying to do in the book is trying to talk about how we got here and how we can maybe get out of it. So the part about getting here, I think, has so much to do with what we're told about the First Amendment, the myth versus the reality. First few chapters are really about saying when we tell ourselves these stories, these really feel-good stories about how the First Amendment is what made it possible for abolitionists to produce their newspapers and to advocate against slavery, or it's what allowed the suffragists to advocate for women's right to vote, or it was what allowed people like Ida Wells to run her newspaper where she talks about the horrors of lynching and tries to bring this to the general public. I go through all that history and I say, tell me where the First Amendment was in any of those cases. Where was the First Amendment when Elijah Lovejoy is staring down a pro-slavery mob and he's saying, I'm going to exercise my freedom of expression to talk about the horrors of slavery and advocate for it to be ended, and then he's shot to death by the mob. It's not a First Amendment story, right? When Ida Wells's printing press was burned to the ground, her newspaper was called the Memphis Free Speech. Free speech was burned to the ground, and she was threatened with lynching, and she had to stay away, essentially, because she never knew if she went back there whether she'd be killed. What was the First Amendment doing there? When the women who were protesting outside the White House for women's right to vote, when they were being assaulted by the men who were angry about this, when they were being hauled off because they were blocking traffic and they were being tortured in prisons, where was the First Amendment? And one way to get around all this is say, well, yeah, that was, before. Now we have a good First Amendment. Around the 1960s or so, we figured it out, right? Did we, though? And first of all, if we only figured it out in the 1960s, that's a pretty short history of the First Amendment. But we also figured it out in 1969 by no coincidence. The 1969 case that is the marker for most First Amendment absolutists who say this is when the First Amendment really became what it is. Think about who it was for. It was for Clarence Brandenberg, who was a KKK leader, who had invited a reporter and a camera person to a rally he was having, where they all dressed up in their robes, and they had these Bibles, and they walked around burning crosses, and they talked about how they wanted to take revengeance against the blacks and the Jews and the government that was too kind to them. And that got broadcast all over the United States. Now, he's arrested for violating a criminal syndicalism statute, and this was an interesting case because in 1923, I think it was, I could be getting some of the dates wrong, Anita Whitney, much earlier, had been arrested for something really similar in California. And what Anita Whitney had done in her case was she had spoken about how lynching is really terrible and that we're still living in an era where Black men are being tortured and mutilated. And she talked about women's rights, she talked about equality, she talked about labor rights, and she was arrested and charged with violating California's criminal syndicalism statute. And guess what? The Supreme Court says, actually, we think it's fine that you are being arrested for this and that you are convicted for this. We got some lovely language out of that decision, but they voted to put her in jail. When we get to 1969, and now it's Clarence Brandenberg, the Supreme Court, now it's different people, right? A lot of time has elapsed, right? And now they say, actually, we think we were wrong before. We now think that you should only be punished for this kind of speech unless it's really intentional, that you wanted to cause some kind of disruption, and it has to be that it's really close in time, that you wanted to cause this disruption, and it was likely that it was going to cause this disruption, and it basically did. So it's a really, really high standard, the Brandenberg standard. And that has been touted as being, oh, this is when the First Amendment really becomes important. I suggest that there's a reason why the Supreme Court looks at a KKK leader and decides that it's going to change the way that it views the First Amendment, and didn't think that when it looks at Anita Whitney. Now, we may want to pretend that that's not what happened. It's just an evolution, but it keeps happening that way. And we can see that there are some good cases. What we're always told by the sort of classic civil libertarian narrative is, oh, you protect the KKK, you protect the neo-Nazi, you're going to protect all the people those people attack. So if you want to advocate for civil rights, if you want to be someone who speaks about women's equality, then you are going to be protected. It's a trickle-down theory of free speech. Everybody wins. And sometimes that happens, but so many other times it doesn't. And I use a couple of examples in the book when I say, think about something that happened just a couple of years ago. Actress Amber Heard wrote an op-ed for the Washington Post. She wrote an op-ed, and it was mostly about the Me Too movement. It was mostly about how she had had a very publicized divorce from Johnny Depp. And, well, not mostly about that, I'm sorry. She made it was kind of the framework that people thought of. But she didn't mention him, she didn't mention the divorce. She said, when I talked about domestic violence, I became this target for all these people who really hated what I was saying. And that's bad, right? The Me Too movement needs to be protected. These women should be allowed to say these things. And I think you all know what happened next. Now, she doesn't mention any individual. She doesn't make any actual accusation other than truthful statements saying that I spoke about an issue and I was harassed for it. And then she sued. She'd sued for defamation by Johnny Depp. And we all saw what happened. Now, if we were truly the kind of country that says people should be able to say daring things, provocative things, upsetting things, then why wasn't this a free speech case? Why weren't we worried about the defamation lawsuit that was going to cost her millions of dollars? Why weren't we worried about the chilling effect for every domestic violence victim that would ever speak up? Why aren't we worried about the fact that someone who has even more power, and of course, as an actress, as someone who was fairly famous, did have some power, but someone who has so much more power saying, if you speak out like this, I will destroy you. And it won't just be in terms of money. It will be global humiliation. That was the stated goal of dragging her through this litigation, was to globally humiliate her. And who stuck up for Amber Heard at that time? Did the ACLU come writing in and say, we're actually going to take up this case because this is a classic case? The ACLU had asked her to write that op-ed to begin with. But the moment she got sued over it, where were they? So when we say, oh, you've got to protect the KKK, you've got to protect the neo-Nazis, because otherwise who's going to protect the women when they speak? Well, no one is. What you end up with most of the time is protecting those who are consonant in some way with the way that power tends to work. And what I mean by that is, we have told ourselves in the civil libertarian narrative that neo-Nazis and misogynists are people who are really just sort of counter speakers. They're marginalized, they're disliked, they may be really distasteful, but they're the outsiders, and that's why we have to protect them. Not because they're great, but because they're outsiders. That's just not true about our history. Look at our history. Our history has always protected people who say that whiteness is supreme, people who say that men are more supreme than women. People have always advocated for money over everything else, or Christianity over every other religion. That has always been true. So the idea that these are people who are on the outs, well, they may be unpleasant seeming, they may be more radical than some people might like, but the underlying point that they're trying to make, which is that white, powerful men need to be on top of everything, and will only really want to allow other rights to the extent that they do not contradict those. That is the story of the United States. That is not on the outs. It's not a coincidence. So what I suggest in the book is we need to reckon with that history. We need to reckon with the fact that what we've been told about the First Amendment isn't really true. And the way that I sometimes summarize this is to say the First Amendment is neither necessary nor sufficient for protecting free speech. And what I mean by that, a lot of people will agree with me about the second one, to say that, well, we need a lot more than just the First Amendment to protect free speech, and that seems an easier thing to confront. But a lot of people really get hung up on the idea that the First Amendment isn't necessary. My point in the book is to say there were so many people who have never been protected by the First Amendment who spoke out anyway. There are people around the world who speak out and risk their lives every day. They don't have the First Amendment. If you even look at the sort of landscape of who's protecting free speech the most in our global environment, there are rankings about these things, right? The United States ranks 26 out of 160 countries when it comes to freedom of expression around the world. It ranks 55 out of 180 for press freedom. And it's about to get a lot worse. So the idea that the First Amendment somehow uniquely is the way that you get to the best and most comprehensive outcome is belied by everything we know about how other places can handle speech or encourage speech. So beyond all that, the big part of the book is really just trying to orient us in that space and not just believe what we've been told about the First Amendment. And then to ask, well, what could we be doing more? Or what kind of analysis could we be providing that would help us become more committed to the aspirational ideals of freedom of expression? And for that, I looked to the Greeks, because I have a classics minor and sometimes I want to use it, but also because I'm really fascinated by this concept of parresia. So some of you may know a little bit about this if you are also classics minors or majors, and you may, if you're fans of the French philosopher Michel Foucault, you may be aware of his attempt to try to bring the concept of parresia into broader understanding. So in the 1980s, he gave a series of lectures where he focused on this concept and really gave it some contours. And I found this so compelling, because he says the ancient Greeks had multiple ways of describing what freedom of speech was, and they had multiple ways of describing the role of speech in a democracy. And he said, one of those is parresia, which is what he translates as fearless speech. He says, I'm translating it that way and not as free speech because it's very specific, this concept. It's not just the power to say whatever you want to say. He says, isagoria is maybe more of a concept where everyone gets to say something if they want to, and that maybe is important. Although he says there's a lot of places where the Greeks say that conception of speech, if I can say whatever I want and I don't care about the consequences, is actually counter to democracy and actually counter to community. But he says the fearless speech aspect has certain characteristics. And the major characteristics, he says, are, the first one is candor. He says it has to be a person speaking from their own identity. You can't be the devil's advocate. You can't be playing a role. You can't just say, well, I'm just asking questions. You have to be someone who's saying, this is the position I take from my experience. The second thing that it has to be is that you have to be speaking to someone or something that is more powerful than you are. And when you speak to that thing or that person that is more powerful than you are, you have to criticize them. Now, those three characteristics, you have to be candid, you have to be critical, and you have to be courageous, because if they're more powerful than you and you're criticizing them, they may try to hurt you. Those are the characteristics, he says, that you really need in a democratic society, because that's what you would need to protect above all else. In other words, you can't have a conversation that's truly about democracy and speech unless you have an analysis of power. Power has to be there. You can't just say things like, well, free speech or free speech for all, when we know that's not how this works out. The question has to be free speech for whom? Who is controlling it? Who is being silenced? Who is being privileged? Who is being denied? Those are questions you have to ask. Now, that isn't to say that that's the only kind of speech that's worthy or it's the only kind of speech that needs protection, but it should be really central to what we're trying to safeguard in a democracy. And to the extent that there are conflicts between that kind of speech and what I have characterized as reckless speech, and this I would put in neo-Nazis, I would put in the KKK. Reckless speech, by contrast, has nothing to do with critiquing power, has everything with endangering other individuals. Reckless in the legal sense, right? You are consciously aware you are taking a substantial and unjustified risk of harming someone else. So the risk of speaking for the reckless speaker is pushed out onto other people. The risk of speaking for the fearless speaker is something they take on. And at a minimum, what I'm suggesting in my book is we need to spend so much more time thinking about the fearless speakers and so much less time thinking about the reckless ones. The reckless ones are already in control. We need to be thinking about the ones who are speaking out against them, because they are the really provocative, controversial ideas that need protection. So the book tries to do that. It goes through several different time periods and different places around the world to highlight some examples of fearless speech. But what I will say before we open this up for a conversation, I want to end on one, because it really was the genesis of this book. And it was learning about, and for me, it was embarrassingly late in my life when I learned about the White Rose movement in Germany, the student-led resistance movement in Germany. That was one of the first organizations to speak out against Nazi atrocities. And what these students were doing is they would come up with these pamphlets. They would write what was happening, because they were being lied to by their government. We were being told the Germans are winning everything and they're just fighting on behalf of our country. We're just exerting our justifiable force against these enemies. The White Rose would print up these pamphlets and they would say, this is what's happening. These are how many Jews are being killed. This is what is being done in your name. And they would take these pamphlets and they would put them on in various places in the public. They would just stash them wherever they could. Two of the members, Sophie Scholl, I think she was the youngest member, one of the only female members. She was 21 years old at the time. She and her brother were at University of Munich, where they were students. And they had, I think it was the third round of these pamphlets in a suitcase. And they were trying to distribute them around the university. This is 1943, and they realize that they've got some left and they don't know where to put them, but they're sending it this kind of archway in the University of Munich, and they decide they're just going to just sort of send them all flying down, just so that they can flutter down and people can see them. And they're doing this, and they get apprehended by a custodian at the university who was a Nazi member. And he reports them immediately. They're arrested that day. And they are hauled before this entirely, what else to call them? Kangaroo court doesn't even begin to understand it, but doesn't begin to describe it. But they weren't allowed to speak in their own defense. The judge just yelled about how these were people who were sabotaging Germany. They were so unpatriotic. And he sentenced them to death by guillotine. And they were executed that day. And while they're in this courtroom where they're told you can't speak, Sophie Scholl interrupts the judge. She knows what's going to happen. And she says, somebody had to make a start. Somebody had to start saying these things. It was important. They tell her, you cannot speak. Later, as she is being led to she is 21 years old. She's a student. She's being led to the guillotine, and she has a cellmate who recorded her last words. And her last words, I can't even get through them because they are so profound. She knows what she's headed towards, and she says, it is a beautiful day, and I have to go. But what does my death matter? What does my death matter if it inspires other people to speak the truth? And she says, I am sure that the students are going to rise up. On her way to the guillotine. When I'm reading this and I'm thinking, the heroes that we are told in our First Amendment history are Clarence Brandenberg, it's the neo-Nazis in Skokie, and I think none of those people come anywhere close to embodying fearless speech the way that Sophie Scholl does. That is what it means to speak bravely. That is what it means to speak fearlessly. Why don't we talk about this? Why aren't these the examples that give us some sense of how powerful, how valuable, how wonderful speech can be? So that is honestly why I wrote the book. That is the kind of example that I want to spend time on and learn from. So thank you all for being here to hear a little bit about this book, and I'm looking forward to questions.
Yeah, so I'm sure like all of you, I have chills. And you'll see reading the book that, the mic's not on yet. We're waiting for are we pushed? Oh, okay, hold on. Does it work now? How am I doing? Okay, good. Oh, I'm so glad. So I'll repeat that just because I feel like I'm still tingling. So thank you for that. Your magnificent book, which is so powerful, and it just reading itself. I was reading it when we were driving to DC for your book launch a couple of weeks ago at GW. I was reading it to Lou aloud, and we both got chills as we came. And so, thank you for bringing it to us in your incredible way of just seamlessly bringing us your work in such a powerful way. And we're going to ask questions, but I didn't want to screw up and not thank our extraordinary friends at UVA who make all this happen. I see Rebecca and Laurel and Julia and our friends at IT. I see y'all. Thank you so much. They are, Diddy, I see you, magnificent. So thank you so much for making all of this happen. So I apologize that I didn't start with that. It's just been extraordinary. So what we're going to do is start off each with a question, and then we'll open up our students. Lisa, do you want to start?
I'd actually like to start off saying something and asking a question, because first of all, I was about to snarf everywhere with tears watching you. She is the fearless speaker above all. It is a privilege to just be in this room with all of you and to sit here, but you are in this book. You are this book, and I've got 3 children who are going to be reading about you and your story, because Marianne has sat there and fought and gotten threats and been essentially stomped on and had her reputation damaged, and has, it still hurts. We're human. And I want to thank you for that, because that gift is your legacy.
Thank you, Lisa.
1000x right there.
My next question is, why do you always go back so far in history? Oh, I'm not sure if it's this date. I don't even know what day of the week it is. I had to ask you over there when we signed that paper.
Why so back in history?
What is it about dipping back into history that inspires you in that way?
I think it's because so much of the story behind our First Amendment, right, is a story of a legacy. What we get taught, I think, is in many respects is the United States has always protected the outsider. The United States has always protected those who've spoken out. And I feel like it's really important to retell the story, and it's hard because those are our bedtime stories, right? Those are our mythologies that we really keep close to our hearts. They are quasi-religious for a lot of us, right? but we've been lied to about a lot of it. So for me, it's so important to go back and say, well, let's actually talk about the people who stood up. We can be proud of the people that gave us a legacy of freedom of speech without wrongly attributing it to the law, because that's not what was operating, right, in the late 1700s or throughout the 1800s. These were people who knew that they weren't going to get protected by the law. If you read, one of the first things that I talk about in the book is the burning of Pennsylvania Hall, which is something that people mostly don't really ever even talk about. So this is an entire project dedicated to freedom of speech, and it's dedicated to abolitionism, and it's dedicated to women's rights. And it's this beautiful hall in Philadelphia, and all this time and all this money went into it. And the moment they start having these conversations, the moment that they start having the kind of conception that we might want to really respect and say this is freedom of expression, means things like let's counter what's happening right now. Let's counter slavery. Let's counter the fact that women can't vote. A mob burns it to the ground. Burns it to the ground. And this isn't just about saying, well, there's a difference between what the government can do and who the government should protect and whether or not private citizens can. The mayor knew what was happening. The speakers went to the mayor and they said, you've got to do something about this. You've got to think about how bad this is getting, because there are mobs outside the doors, right, who are listening to these speakers, to these anti-lynching speakers, and they're threatening them. Please come and help us. Please come and put some, and the mayor said, well, there's really nothing I can do. And then after it burns to the ground, the newspaper reports, especially in the South, say, well, really, what could they expect? You had black women and white women mingling together, or black men mingling with white women, and they were talking about all these things that are about racial equality. Women's equality. Well, what did they expect would happen? So that's why I think it's really important for us to talk about that history, because we don't really tell ourselves those stories very often. I think they would bring us to a different conclusion than I think what we normally conclude about our legacy.
So my question is, so often we're told, there's another myth, that the First Amendment is a wonderful floor, but yet we have yet another protection, Section 230 of the Communications Decency Act. Thou shalt never touch that either, because that's even better. I would love for you to reflect, now that we've seen the disassembly of trust and safety across these biggest platforms, to reflect a bit about that myth. That we ought to keep these companies immune from liability.
Yeah, so just to give a little bit of table setting, we know that the First Amendment is quite powerful in the sense that there's a lot of things that the government's not supposed to be able to punish you for. There are some exceptions to that, but so we already know that that's pretty powerful. On top of this, though, in 1996, Congress decided that it was going to enact this law called Section 230. Well, it wasn't called Section 230, but it's what we'd say it is now. And it was an attempt to sort of think through what's going to happen now that we have this thing called the internet, right? Because no one really knew that much. I mean, it seemed pretty cool to some people at the time, but it's the 1990s, right? And very little is clear about what's going to happen, right? We're talking about message boards. We're talking about pretty basic email. We're there, it was only a few years by that point where there had even been images supported by browsers, right? So it's really early. And the question was, well, what should we do to regulate this? And there were a lot of calls to regulate. And as you might expect, a lot of it was very reactionary. It was, what are people going to get up to if they have this kind of terrible, terrible freedom? So there were a lot of especially conservative-led movements to say, well, we need to crack down on all bad things that are happening online. It was mostly about concerns about porn, right? Porn is going to not only flourish, it's going to be accessible to really young kids. We can't let that happen. So we're going to try to regulate it. This was kind of a response or an attempt to say, well, let's not do that. Let's not regulate, but instead of proposing something maybe more moderate or more sensitive to these dynamics, basically Section 230 was written, or at least it was interpreted soon after, as being basically no regulation at all ever. And not only no regulation, but this. When you think about how situations like this, or newspapers, Fox News, whatever it is, if they do something, for instance, like defame a voting machine company, right? If they bring on a bunch, if there are Fox News hosts who say, well, I'm going to just have this person come on and talk about how there was all this voting machine fraud, and it turns out that that's false, they can get sued, right? Fox News can get sued, not because Fox News was the one saying it, but because they invited people to their platforms and let them say false things. So you may have heard about this case where Dominion is suing Fox, and they're allowed to sue them because that's the kind of thing that you encourage people to take, not encourage, but you force people to take responsibility for things that they contribute to, even if it wasn't necessarily their express intention. But what happens if you do the same thing online? Same lies, even more so. Let's say that Elon Musk is fully aware of the lies that he is spewing, right? Can he be sued? And the answer is no, because of Section 230. Because everything's different online. The way that it has been interpreted is to say, not only can we not regulate you, all other ways in which you might normally be able to bring a case, maybe whether it's defamation or whether it's some kind of harassment case or whether it's, revenge porn, whatever it is, we're going to say basically anybody who owns a platform is immune from suit. They just have no liability.
From liability.
From liability.
But always remember this when someone says, well, can they sue me? People could sue you for whatever they want, and they have, right? It's the liability that they're just not going to be liable. You can sue them, you can make them have to respond, but
well, I think part of the problem is that you can't even really do that, right? So the immunity shield, because it doesn't just say they won't ever be found liable, it says that you can't even start the process. So many of you know, right, especially if you've ever had Professor Citron, right, how this process works, discovery, right? So when no matter where the suit comes out ultimately, whether there's a settlement or whether or not we find there wasn't liability, that process of getting there, getting inside the court, getting that information, ordering discovery tells you so many things. Think about what happened with the tobacco industry. There were so many people within the industry saying, oh, we don't know anything about cancer. What are you talking about? And then you uncover through those litigations, you see, wait, you knew a lot. You knew a lot deliberately. That's how you find these things out when they're not willing to tell you. So when Section 230 says preemptively, you can't even get in the door, that's what we're being shielded against. Whether or not they're ultimately responsible, whether or not we want to hold, the owner of a company responsible for something that a poster says, that's a whole different question. But the fact that we can't even start that process is something that is not only an extraordinary sort of deferential attitude towards an entire industry, a very powerful industry. And I think I say in several of my works that the only other industry that gets anything like that deference is the gun manufacturing industry, because there's a very similar immunity shield for them. But it's not the way that any of this works otherwise. All of us could get sued if we say something that someone takes issue with. They may not win, but we could get sued. But Elon Musk cannot. That's an amazing thing. And the idea that many people who defend Section 230 would say is that, well, it's even better than the First Amendment because it means you have even...
In celebration.
In celebration, they say it's better than the First Amendment because it means that all speech is going to be promoted, because the theory there is, whether this is sincerely meant or not, but the theory is, well, because you can't sue them, they're going to allow all kinds of speech. They won't ever take down bad speech. They won't take down speech that they don't. They'll keep everything up. That's the theory. But that's the bad theory that wasn't even true about the First Amendment, and now it's being even more, it's given even more sort of preemptive power when it comes to these private entities that can do whatever they want. And what do you think the result of this is? Well, if you are Elon Musk and you have political ambitions and you know which candidate you want to have in office, what do? You turn your platform into a right-wing propaganda machine. And what will the consequences be other than the destruction of democracy? Well, no personal liability.
So before I hand it over to our amazing students, I wondered if I had asked you when we were at the GW event, and I thought you just might share a bit of what you had responded to this question, which is, even the Black Lives Matter movement, important to that movement, of course, we're social media platforms. And of course, before BLM, we've had so many social movements that, pre-internet, that were able, so Dr. King could lead the movement of nonviolent resistance for civil rights. Might we have, so this was Lou's question to me in the car that I asked you, so I'm asking today because the answer was such a brilliant one. And I want Dr. Franks to share it with you. Even now, given the changes in technology, might we be able to see those fearless speakers with the state of the law and understanding of the First Amendment? Are you worried that we can't have those breakthrough moments, right? Breakthrough moments for civil rights, for equality, for free speech of the fearless speaker?
I mean, I do wonder what the spaces would look like where that kind of visionary thinking would actually emerge, right? So could you imagine a Martin Luther King on Twitter? I say this, I mean, one of the things that I sent to Danielle in the lead up to the election was, I don't know how many of you may have caught this, but there was a deep fake of Martin Luther King on Twitter right before the election. And it co-opted him into saying, basically that the only people who will protect Black people are Republicans and you need to vote for Trump. And What it really made me think about, because Danielle and I have worked on deepfake issues before about, especially sexual exploitation and the question of, what do you do about that? I was thinking, this isn't, the categories I normally think of, well, sexual exploitation shouldn't get a pass just because it's a deepfake, and also things that are just completely false, that are misleading to people, that they will believe when they're not true, that shouldn't get a pass either. But I'm looking at this, I'm like, this is neither of those things, but it's incredibly devastating. And I couldn't even articulate how devastating it was to watch. So what would happen? I think what we would see is something more like that. Whatever emergent voices you get would get immediately co-opted or threatened to such an extent that they would be driven off of the platform. But as I said at GW, when you asked this question, was do we even look at Martin Luther King as a success story for the First Amendment, because he was shot, right, for peacefully saying the things that he was saying. Those people in the civil rights movement, we say, well, look, what did the First Amendment do to keep people's heads from being cracked open by the cops every time they protested in a way that was considered unacceptable, right? We take credit for this legacy, and we should, in the sense that we should give credit where credit is due, but was that the law? Was that the law that was helping us? Was it the First Amendment that was helping us? Or was it these people who were brave enough to do it even though they weren't protected by the law?
Just a super quick comment. A lot of where we've spent the last 10 years working is you're drafting legislation, you're working on it, you're working with certain leaders who we wish we were able to talk about more today. And then I'm in court at telling them how it's actually working out, right? Because it's not what you set out to do and what actually happens, right? So as an example, so recently, and it took 10 years, I'm kind of like, woohoo, right? Pop my cherry. I have been threatened with deepfakes if I don't stop representing my client. And apparently that worked for this person, for all the lawyers that represented her before, but she didn't do her homework.
Oh, no. No.
And I'm not stopping, right? And that's scary.
It's scary to be a fearless speaker.
Well, indeed. And I mean, this is, something I was going to, this is part of the gratitude that I was expressing at the beginning, because as you all know, Professor Citron has given us so much of the theory that makes it even possible to have these conversations, to try to rethink the law, to try to ask more of the law, right? And to see where it is failing us. And Elisa, for years now, I don't even know how many years it's been, has been in practice, just being out there representing people who had nobody else who would listen to them. And this pro bono project was saving people's lives. I mean, the number of women who are suicidal when these things happen to them, who have lost everything. And Elisa just gets up there and fights for them, right? And what eventually was going to happen was that she was going to become a target of exactly the terrible kinds of forms of image exploitation that she's fighting against. It was inevitable in a way. It doesn't make it any less tragic or upsetting. But I just want to highlight how this is the cost of that. And
It's an occupational hazard, frankly.
Which it should not be. But I am humbled by this, the fact that you are still willing to do that, because it's not the first time either Danielle or Lisa has been attacked by people for what they do, and yet people still do it. And this is what gives me some hope.
Well, you're our hope. Okay, so I'm going to have our students in the last couple of minutes ask questions. So I've got, look at this, an embarrassment of riches, and then I'm coming up. Okay, so the three of you, we're gonna have time.
Hello, yeah, thank you for coming. But I was super interested in, like you said, that use the phrase constructed reality when you were speaking. And it seems like a large part of the conservative movement's argument is for more conservative algorithms for which we get the information from. And so I'm curious to see, there's been a lot of pressure on Google, Sundar Pichai, to de-wokify Google search, make it more, make their AI more like Twitter's AI or search algorithm. And so I'm curious to see, kind of continuing off Professor Citron's question, is it even possible to have an MLK or these sort of people appear on social media when the algorithms are basically geared against them?
That is such a good and depressing question. One of the other things that we know about Musk's regime was that he tweaked the algorithm so that his own posts would get more views. This all happened when he was watching a game, I think it was, and he tweeted out something, and was it Biden who tweeted out something, and somebody else was getting more tweets, and he actually left the game, went to his headquarters and said, tweak the algorithm until mine get more views. That's what we're dealing with here, right? And yes, aggressively sort of ramp up the algorithm to promote right-wing content. But I also want to suggest too, I mean, things have gotten so much worse, but it's not like things were good at Twitter before. It was already the case under previous leadership that right-wing content was constantly being maximized. It was always a lie to say that conservative speech was being suppressed. That's always been a lie. Every single study that investigated this found that, in fact, right-wing content always performs better. And that's either because things are actually ideologically aligned in this way, that there were commitments made by these major companies to do that, or it's simply what happens when you are maximized for outrage. There is a certain kind of content that will always rise to the top, and it's not going to be progressive content, right? Well, it's going to be progressive content if you're in the wrong spaces, I guess, to generate that outrage. But that's going to be the problem. So I do think that that's going to be a real danger, because it's going to become even more so the case now that he's got governmental power behind him as opposed to just social power. But one of the things I say in the book, and this is it's not a good response, but one of the things I'm hoping that we're learning from this catastrophe is don't trust corporations to have your best interests in mind. If we want to keep having powerful spaces for speech, it may just be the case that social media is not it. But we have so many other spaces. People talked before social media. They still talk now. We're talking right now. There are spaces, there are places where we can do this. And we may just all need to unhook, because it may not be good for us in any meaningful sense to stay on social media the way we have been.
So with everyone's indulgence, we have two questions that we're gonna, if you stick around if you want, but I know time's up, but we're staying. So Corinne and then yes.
Hi, thank you so much for coming, and I loved your book. I'm curious, if you keep today's realities in mind, if you started with the text of the First Amendment or some other statement about the normative value of expressive freedom, but if you wiped out all of the doctrine that we have, how would you design First Amendment doctrine or free speech doctrine, keeping in mind your values of privileging fearless speech and not giving so much attention to reckless speech?
So this feels like a loaded question in some ways, partly because I think maybe some of you know about this, but a few years ago, the Boston Globe actually did an experiment. They had a whole project where they said, let's reimagine the Constitution. And I was asked to reimagine the First and Second Amendments. Now, this is a thought experiment, right? So I thought, well, this is fun. I'd like to try that. And what I ended up doing, and you can go and see what I wrote, because it got a lot of press. Including by, well, I won't say by whom, but so one of the things I did in my reimagining was I corrected, for instance, the Congress thing, because that's weird, because we know that it's not just Congress. That's incredibly misleading. So I think it was something along the lines of that people have the rights of freedom of expression subject to responsibility for abuses of those rights. And that language actually comes directly from many, many state constitutions whose First Amendment-like analogs actually include this phrase. And original versions of the First Amendment also had something like this. But the blowback that I got for even suggesting that, I mean, the number of people who said things like, what even would that mean? I was thinking, well, that's the majority of state constitutions use that phrase. You probably live in a state that actually has this as their law, but you're really mad at the idea. And we do this all the time in the law. We say, yes, you have a right, and it has some limitations for abuses of that right. That seems like a very modest place to start. So and not modest in the Jonathan Swift sense, but really truly modest place to start. And I would do something like that, I think, if we were to do it over, if we had that chance to say something about that, to make it so that we were clearer about what it is that the First Amendment actually does or should do if we want to preserve democracy.
Hi, yeah, I'm hoping that this isn't too much of an overlap, but you're talking about how in First Amendment doctrine and when we're teaching it, we kind of prioritize certain stories of reckless speech over the ones that you would prefer to spend more time on, which is the fearless speech. But I guess I'm wondering, like, how, maybe in terms of like your methodology, when you're teaching about like the First Amendment, how you reconcile like making sure that the students that are going to be going and having to make these claims before courts are covering like the material that might be most appealing to courts, while also being able to kind of engage in this more imaginative, like thinking about the law.
That's a fantastic question. And it's a great question about pedagogy, which to me is not just what I do in the classroom, but hopefully what, I do with my life, which is, but starting from the classroom, what I try to say to my students is, I want to teach you, first of all, the law as it is, and then I want to invite you to think about the law as it could be. And so that's always my goal, is to say, I'm trying to describe, I want you all to understand the descriptions of the law, that I'm trying to give you accurate ones first. And secondly, let's think about the prescriptions of the law and how they could or should be changed. But I always have to emphasize with them, those are not the same thing. And I want you to know the law, no matter if I think it's unjust or I think it's unfair, you've got to know it, because that's my job, is to actually communicate to you what the law says. But it also means that when I do that, when I'm teaching the First Amendment, I invite them to not just accept what they've been told these cases mean, because that's also not descriptively accurate, right? The idea that we always, for instance, when the Supreme Court itself, this is an example I use a lot. 2010, there's this, Congress passes a law against what is called animal crush porn. So these are these horrible videos where people are stomping small creatures to death. The Congress says this is terrible and it's driving up this market for this kind of thing. We need to put a stop to it. So it bans it, basically. And that gets challenged. It goes up to the Supreme Court. And the Supreme Court says, you can't ban this sort of thing. There are 5 historical categories of things that are exceptions to the First Amendment. There's no others, basically. There might be some in the future, but this is not one of those. We never do balancing tests. These lower courts were saying, well, this is really harmful compared to what the actual benefit of the speech is. We never do that. That's a lie. You look at the case, the Ferber case, 1983, where they find that child pornography is not protected by the First Amendment. What do you think their analysis was? It wasn't something like, it's a historically non-protected category, because it wasn't. They had to actually do an analysis that says, is this more harmful than it is worth? And if the answer is yes, then we're going to say it's not protected by the First Amendment. So I try very much to not give them the orthodoxy, right? I try to say, that's what the court's telling you it's doing, but is that actually what the court is doing? Is that actually the right way to describe this? But yes, to your point, I think you have to know what the law is, the world is, before you can do anything to change it.